I request everyone to turn on their video camera if they are comfortable on that. Hello everyone, a very good evening to all of you present here. Welcome to today's webinar on the BNSS impacts and implications for modern criminal law, organized by Legal Vidya. My name is Parastu and I will be your host for today's session. We are thrilled to have you join us as we delve into this the amazing session on the BNSS impacts and implications for our modern criminal law. This topic holds critical relevance in understanding the evolving dynamics of criminal justice systems and the challenges posed by our contemporary legal frameworks. The BNSS represents a multidisciplinary approach about our new criminal law, from analyzing criminal behavior through about our social impacts or societal impacts. These will give you insights how laws are applied. Whether you are a law student, a practicing criminal, or a professional interested in the intersection of law, this section offers a valuable insights. We will explore the impact of behavioral cultures in the criminal intent, the role of law in assessing culpability, how it works, how it addresses some things, and all in the criminal justice. Today, our main focus will be on the examining key concepts within the Bharatiya Nagari Suraksha Sanhita framework, understanding the implications for modern criminal law, and discussing about our new law which can enhance justice delivery systems. This is a unique opportunity to broaden your perspective. This is a unique opportunity to broaden your perspective, gain insights, and contribute to meaningful discussions at the intersection of law. Before we delve into this session, let me take a moment to introduce Legal Vidya to you. Legal Vidya is established in the year of 2021. There is an online and tech platform that is committed to shaping the future of legal education. Our mission is to create our mission is to create opportunities that empower learners at every stage of their legal journey. We offer a wide range of programs, including internships, webinars, workshops, courses, seminars, conferences, competitions, meticulously designed to create diverse learning that needs within our legal field. In addition, Legal Vidya provides a vibrant platform for individuals to showcase their expertise through article publications, fostering through a thriving community of legal discourse, knowledge sharing, and innovation. At Legal Vidya, we believe in equipping aspiring legal professionals with the tools, insights, and skills they need to succeed in a rapidly evolving landscape. Together, we are building a brighter future for the legal fraternity. Now, it's my absolute pleasure to introduce our today's speaker, that is Miss Anshu Sharma Man. Miss Anshu Sharma Man, a former judge in the Gujarat judiciary, has built an illustrious career marked by remarkable achievements, an unwavering commitment to justice, and a vision to transform the legal landscape. Her legal journey began with her appointment as an additional civil judge and judicial magistrate, where she handled intricate legal matters with exceptional skill and fairness, earning widespread respect within the judiciary. Her contributions to the judicial system reflect her steadfast dedication to upholding the principles of law and equity. Ma'am can a testament to her versatility and intellectual brilliance. She initially earned a degree in electronics and communication, showcasing her multifaceted capabilities. Later, she pursued her passion for law, obtaining an LLB degree with first earning the prestigious Best Alumni Award. Not stopping there, she completed her master's in business law, again emerging as a top performer for her outstanding academic achievements. These milestones exemplify her relentless pursuit of knowledge and her determination to excel across diverse fields. As a passionate and innovative educator, Ma'am has played a pivotal role in shaping the future of legal education in India. She has served as a visiting faculty member at several esteemed institutions, that is, including AMSOM, Nirma University, Karnavati University, and many prestigious colleges. and many other universities also. Her dynamic teaching style, practical insights has inspired countless students and excelled their legal careers. Beyond her contributions to academia, and Ma'am has made a profound impact on the legal community through her active involvement in training programs, workshops, and seminars. She has conducted specialized sessions at premier institutions such as Nirma University, Gujarat University, and Ahmedabad City Civil Court. Her expertise has also been extended to the training advocates, judicial officers, and court staff in districts like Ahmedabad, Rajkot, and beyond. Her practical insights and ability to bridge the gap between them. Also, ma'am has founded a movement academy, a groundbreaking institution that incorporates creative animation, cutting-edge teaching, methodologies, and progressive techniques into the training of aspiring legal professionals. So now, a quick housekeeping note before we proceed. This webinar will be recorded, and the recording will be shared with all the registrants. I kindly request all the participants to keep their microphone muted, and if anybody or you are comfortable in opening the camera, and please on your video camera of your front camera, not your back camera. This some of are open their back camera on that. I request everyone to open their front camera, not back camera. Also, if you have any questions, you have to ask at the end. A feedback form will be provided at the during the session, and we would greatly appreciate if you could take a moment to fill it out. Without further delay, let's extend a warm welcome to our esteemed speaker, Ms. Anshu Sharma ma'am. We are excited to hear your insights. The floor is yours, ma'am.
Thank you, Bharashji, for the wonderful introduction, and thank you, Team Legal Vidya, for inviting me here. So, without further ado, I just start with today's session. I hope all of you can see the screen up. Can all of you see the shared screen of presentation?
Ma'am, just give me a second. I will do.
Yes. Okay.
Ma'am, now we can start.
Okay. Just 1 second. Can you just help me change this slide? Because I'm just making it. Just 1 second. I'm not able to change the slide.
Ma'am,
I'm not able to change the slide. Just give me 1 second, please. I'm unable to change the slide from me.
ma'am, close your shared screen, then after then again present the screen.
Yes.
Now,
Okay. Yeah. Can you keep the phone here? Okay, let's start. I'm sorry for the technical glitch that we just had. I hope all of you are able to see the screen now. Yes. Just a second. Okay, let's start. Uh, Hello, everyone. Today, basically, we will be discussing some major reforms which are present in the BNSS, which were not there in the CRPC. Well, there are a lot of new changes that are there in the new BNSS, but they were not in the CRPC. But due to paucity of time, we will be able to cover 10 only. Okay, so today we will cover 10 major changes that are there in the BNSS, which are not there in the CRPC. To make this presentation a bit interesting for all of you, what I have done is I have also added a lot of clips here. So 2, 3 clips I have added. So I hope you will enjoy today's session and also you will learn out of it. I was being told that we have a lot of students here. So I'll try to not make it very technical today so that all of you can understand completely. And in case if you have any doubts, then I'll take it once the session ends. Okay, let's start. Before taking up BNSS, I'll tell you how to study big acts. Okay, so if you take up BNSS or if you take up BNS or BSA or CPC, all these are big acts, right? So how do you study these big acts? So basically for studying any big act, what you have to do is you have to divide it into parts, okay? So I'll tell you how to study these big acts. You divide in parts, for example, BNSS, I have divided into 5 modules. So first, the any act in any act, section number 1 is short title, extent, and commencement. What is short title? Short title is the name of the act. Okay, for all the ones who are preparing for judiciary, kindly note down that the name of this act is very important, and it is highly probable that you people might be asked the name of this examination. So they might give you confusing options. So the name of the act is Bharatiya Nagrik Suraksha Sanhita. Okay, so they might ask you the name of the act. So short title is name of the act. Then you have extent. Extent is so extent is where it is applicable, to what extent it is applicable. So it extends to the whole of India. Then from which date got enforced, so that is commencement. So when it got commenced. So short title, extent, and commencement, generally it is section 1 of all the acts. Section 2 is definitions. Here BNSS in the first 34 sections, there are hierarchy of courts. Then 35 to 62, there are provisions of arrest. Then from 63 to 93, there is appearance of persons. 94 to 110, there is appearance of things. 144 to 147 is a very important segment with respect to all examinations, that is maintenance. Investigation procedures are given from 173 to 193. Then 194 to 996 is inquest. Trial is 223 to 288, and post trial is 289 onwards. You can take a screenshot of this. This is very important. It is going to help you to study this act thoroughly. Okay, now let's start with today's session. Why was BNSS introduced? Okay, what was the need of a new act when CRPC was already there? Why new act was introduced? So basically, as we all know that uh, with the change in technology, with the contemporary times, as there is a recent development with respect to, for example, online payments, online frauds. So there is a lot of for example, if you have artificial intelligence these days, so with advancement of technologies, there was a need to fuse it with legal changes also. So BNSS was introduced in order to couple this change of law with fusion of technology. Now they had inserted a lot of important sections in BNSS which were originally not there in the CRPC, like online registration of FIRs or zero FIR. So new things they were introduced. Now I'll take up 10 major changes that are there in the BNSS which were not there in the CRPC. Starting with the first. The first major change was zero FIR. Now, what is zero FIR? I'll just give you a brief overview. What is zero FIR? What is FIR? FIR is first information report. where is this first information report registered? आप इसको कहाँ register कराते हैं? So you'll get it registered in the place or in the police station, technically in the jurisdiction of which the crime has been committed. For example, if I am here in Ahmedabad today, so in Ahmedabad, if a crime has been committed, if it is committed in satellite area, if it is committed in Anandnagar area, I'll go to Anandnagar police station, right? So generally, FIRs, or for that matter, FIRs are lodged where the crime is committed. Now, in the famous case of Sushant Lok rape case, you know what happened? So there was this rape case which took place in Sushant Lok in Gurgaon, which is in Haryana. Now this female with whom the rape had been committed, the aggrieved party, the victim, she approached RK Puram police station, which is in Delhi. Now, RK Puram police station did not have jurisdiction to lodge the complaint because since the rape had taken place in Sushant Lok, Gurgaon, RK Puram police station lacked jurisdiction. Now, in this landmark judgment, it was being held that instead of saying no to the victim to file FIR, what the police should do is they should register FIR and they should not number it. Since these FIRs are not numbered, therefore they are called zero FIRs. Why they are called zero FIRs? Because they are not numbered. In CRPC, this was not a statutory provision, though it was already there by way of judgments, by way of precedents, but there was no statutory provision. So in BNSS, with the provision of FIR, they have also now inculcated zero FIR as a statutory provision. So in case if a crime has been committed, a victim can directly go to any police station. The police station authorities cannot say no for lodging a complaint just because they lack jurisdiction. What they can do is they can register a zero FIR and then they can transfer the case to the police station which holds jurisdiction. And then this police station which has jurisdiction can register the FIR with that particular number. Okay. The second major change that was there in BNSS was with respect to the hierarchy of courts. In the original CRPC, in the CRPC, courts were divided into two parts, which was courts were divided with respect to metropolitan areas and non-metropolitan areas. So basically, in metropolitan areas, there were courts of metropolitan magistrates, whereas in non-metropolitan areas, there were courts of judicial magistrate first class. But after the implementation of the new act, which got enforced on 1st July 2024, the courts of metropolitan magistrates have been abolished. And as per the new act, that is as per BNSS, now there will be no courts of metropolitan magistrates, only courts of judicial magistrate first class will hold good. Okay, so this is the second major change. I will keep on repeating the changes. So first was zero FIR. In CRPC, there was no statutory provision of zero FIR. Whereas in BNSS, now there is a statutory provision of zero FIR. Second, in BNSS, in hierarchy of courts, now the courts of metropolitan magistrates have been abolished. Now there is only court of judicial magistrate first. Does someone want to say anything? Okay, sorry. So in BNSS, basically, the courts of metropolitan magistrates have been abolished and there is only court of judicial magistrate first class. Okay. Now the third major change was use of handcuffs. In DK Basu versus State of West Bengal, in Prem Shankar Shukla versus Delhi administration, in these cases, Supreme Court was very strict with the use of handcuffs or leg. They had given clear directions that handcuffs or leg chains should be avoided, and they should be resorted to strictly in accordance with the law. And this was repeatedly and time and again explained in various judgments by the Honorable Supreme Court. So as per Supreme Court, the handcuffs or leg chains could only be used as insurance against escape, which does not compulsorily require handcuffing. So, in case if you feel that the accused is about to escape the custody, or in extreme circumstances, only you could use handcuffs. But the new act, that is BNSS, permits the use of handcuffs in various cases, which includes organized crime, which contradicts directives laid down by the Supreme Court. So, according to Section 43, Clause 3, this is a major change. It says the police officer may, when we use the word may, it means that it is a discretionary provision. The police officer can use handcuffs. In which cases? In cases of habitual or repeated offenders who have escaped from custody, or who have committed offenses of organized crimes, terrorist acts, drug-related crime, or illegal possessions of arms and ammunition, murder, rape, acid attacks, etc. So the list is already given. In all these cases, here, in as per the new act, the police officers have been given discretionary power of using handcuffs. So this is technically in contradiction of what Supreme Court had iterated. The Supreme Court was very strict with the use of handcuffs, but the new act has given discretionary power to police officers, who can use handcuffs in all these cases. So this is the third major change. I will, as I mentioned before also, I will keep on repeating the changes so that by the end of the session, you people are well equipped with all of them. First is the registration of zero FIR, which was not a statutory provision in the old act. Whereas in the new act, zero FIR has become a statutory provision. So you can get an FIR registered at a police station which does not have a jurisdiction without any number. That is why it is called zero FIR, and then this FIR can be transferred to the police station having jurisdiction, right? Now, number 2 was abolition of courts. So metropolitan courts have been abolished, and now there will only be court of judicial magistrate first class. So there will be no bifurcation of metropolitan areas and non-metropolitan areas. Now, the third major change was use of handcuffs. As per Supreme Court of India, handcuffs should not have been used and should have been used in strictest of circumstances. But as per the new act, handcuffs may be used by police in all the cases which are being described under 43 clause 3. Now I'll show you a clip with respect to forensic investigation. I'll show you a small clip which I got from internet. Okay, this is with respect to forensic investigation. Let's start with the clip first.
क्रिमिनल की पूरी हिस्ट्री सिर्फ एक धागे से निकल सकती है क्या? आपके लिए ये सिर्फ एक मामूली धागा या मिट्टी हो सकती है, लेकिन हमारे लिए ये किताब है, किताब अपराधी की पूरी लाइफ हिस्ट्री की। गौर से देखेंगे ना, पूरी कहानी खींचेगी। एविडेंस इकट्ठा करने में फर्स्ट रिस्पॉन्डर की अहम भूमिका होती है। ये उनकी रिस्पॉन्सिबिलिटी है कि क्राइम सीन इंटैक्ट रहे और अनटेम्पर्ड रहे, ताकि फॉरेंसिक साइंस लैब एविडेंस इकट्ठा कर सके। ये एविडेंस कोर्ट में पेश करने के लिए एक चेन ऑफ कस्टडी का होना जरूरी है। मामूली चीजें जैसे रेफरेंस नंबर, FIR, तारीख, टाइम, आइटम डिस्क्रिप्शन और कलेक्टिंग ऑफिसर की आइडेंटिटी भी बहुत इंपॉर्टेंट है। केस को बिल्ड करने के लिए फॉरेंसिक का रोल बड़ा क्रिटिकल है। अगर एक छोटी सी भी गलती होती है एविडेंस इकट्ठा करने में, कोर्ट में आपका पूरा केस इनवैलिड हो सकता है।
See, forensic investigations are very important. ठीक है? If you miss one small evidence, it basically affects the whole trial, right? So BNSS now mandates forensic investigation for offenses punishable with at least 7 years of imprisonment. So now the new act says that in all the offenses which are punishable of imprisonment up to 7 years or more, in such cases, forensic investigation is mandatory. In such cases, forensic experts will visit crime scenes to collect forensic evidence and record the process on mobile phone or any other electronic device. Okay, so if a state does not have a forensic facility, presently in India, there are a lot of states, there are a lot of cities which do not have forensic facility. So what will these states or what will these cities do? So again, there is a provision in the new BNSS which says that the nearby state or the nearby city can send the forensic team to such cities where there is no forensic facility till the time a forensic team is developed in that state. So for all offenses which are punishable up to 7 years or more of imprisonment, forensic investigation has become mandatory. This was the fourth change. Now, the fifth change is electronic mode of investigation. Okay, this is a very, very interesting change. I'll again show you one small clip, and it is very interesting. Acha, you must have seen in foreign or in countries outside India, generally, what does the police do? The police have body cameras, right? These body cameras, they generally record the entire investigation procedure. If you record the entire investigation procedure, generally the electronic footages not only help the court but also help accused taking its defense or the prosecution. So basically all these electronic modes of investigation play a very important role. Now I'm going to show you one clip. So I again got this clip from internet. I'll tell you what happened. In this case, the alleged accused, it was alleged that he had murdered his wife. Now, the people who were working in the same office with his wife reported this to police, that this female was missing from since a lot of days. So they reported this to police. Now the police, when they go to this man, how he behaves, just look at the demeanor of this man and you will understand how body camera or how usage of mobile phone during investigation play a key role. I'll just start the clip.
Hello, sir. How are you? I'm on to the TMS part, please. We're looking for Miss Mamta Kafle.
Yeah, she like on Tuesday, Wednesday, she left and then she said she's gonna go to New York or Texas, and then she left. She had the phone and then she destroyed that phone and then she left.
So she destroyed the phone and she left. She said she was going to New York.
Yeah, our sister, one of our sister.
Okay. Do you have any other contact information?
Yeah, I like she has a different 3 phones. I do have 2 phone numbers. One phone number somebody other receiving, one another contact number for the New York. I do have.
Okay, can you show me that? Can you
Show
show
me
me
those
that
numbers. Show me those phone numbers from you.
Yeah, we just want to see if she's okay because we have it in work.
Did you see how he was fumbling with words, how he was time and again changing his statements? Initially, he said that she has gone to some place which he doesn't know. Then he again changed his statement. So again, this helps. If somebody records these investigations, it helps not only the police to further investigate, but also the court. Again, now this is the Indian police. These are the images that we got from Google. You must have seen these days, police in India also use body cameras. You must have seen on their uniforms, these are body cameras, and they also record investigation. So as per the new BNSS, now I'll come to the act. As per the new BNSS, section 105, it states that when the police conduct a search or seizure of property under chapter 7 or 185, police must use audio-visual electronic means, preferably mobile phones, to record the entire process. So see, when a police goes for search, when they seize the property, again, it becomes very important that they should record the entire process. Why? Because it not only assists in investigation, but it also assists the court, right? Okay. Next is the next landmark change, which was there in the new act, was the addition in section 349. Now the old CRPC says the CRPC empowered a magistrate to order any person to provide a specimen signature or handwriting. I'll give you one example. So suppose if you have signed a check and you say that these are not my signatures, or if you've signed an agreement and you say that these are not my signatures, what the magistrate could do? The magistrate could ask you to give a specimen signature, or they could ask you to give a sample handwriting just to check whether it is your handwriting or yours. Now, as per the new act, these signatures and handwriting also include finger impressions and voice samples. Acha, now, as I just mentioned, that how important it is to have audio, video, electronic means in investigation, the same goes with audio samples also. I'll give you one example. In the famous case of Sheena Bora murder case, Sheena Bora's mother, Indrani Mukherjee. So basically, she was asked to give a voice sample. Why? Because there were some audio clips that were retrieved from some source where it was to be checked whether these voice samples are of Indrani Mukherjee or not. So in order to check whether these voice samples are the ones that match with Indrani Mukherjee's voice, Indrani Mukherjee was asked to provide a voice sample. So now, as per the new act, apart from signatures, handwriting, the courts can also ask for voice samples and finger impressions. Okay, so this is the sixth major change that is there in the new act. Okay. When I was being told that in this class, there are law students, so I was a bit apprehensive whether I should be discussing this section or not. But I will try to explain it to all of you, because I think for the law students who have not studied CRPC or BNSS, it might sound a bit technical, but I will try my level best to explain it in the easiest manner. Okay. 187 is police custody. This provision has changed tremendously. Now I could not omit this section because this section is so important that it is generally asked in all competitive examinations. So I could not leave it. That is why I'm explaining it to you. Firstly, let me explain, because most of you are law students. So let me just explain you what is custody. Okay. So custody can be of two types. One is police custody, and one is otherwise than in custody of police, which is generally the judicial custody. Now, what is police custody? Police custody is when a person is arrested and he's put in jail. Police custody is when he's put in police station. Okay, this is called police custody. Whereas when a person is kept in jail, it is called judicial custody. Is this much clear to all of you? Yes. Police custody is when a person is kept in police station. That is, he's in the custody of police authorities. Whereas judicial custody, it is presumed that he's in the custody of court. That is why it is called judicial custody. Okay. So basically, police custody is the maximum for which a person can be in police custody is 15 days. Okay. I think I annotate on this now. Okay. Anyways, so see, basically I've been taking sessions on Zoom and I'm very comfortable with Zoom. This is for the first time that I'm having it on Google Meet, so I will not be able to annotate presently, I guess. But anyways, I'll try my level best. Police custody, you can write it down. Police custody, the maximum duration for which a can be in police custody is 15 days. What is the maximum duration of judicial custody? It is 60 days in case if the offense is of punishment which is less than 10 years, and 90 days if the offense is of punishment which is greater than 10 years. Okay, so basically I repeat, 60 and 90, can you see on your screen? So for offenses having punishment less than 10 years, the judicial custody can be of 60 days. Whereas for offenses which are punishable of punishment greater than 10 years, the judicial custody is 90 days. Okay. Now, what is the change in the new BNSS? The change is that this police custody of 15 days, how it can be granted. So if suppose if Mr. X or if suppose Paras G has committed a crime, okay? So if Paras G has committed a crime and suppose if the maximum punishment is 7 years, correct? So maximum punishment of that offense is 7 years. Okay. So what can be the judicial custody? Maximum judicial custody we can be 60 days. So in such a case, if he is in judicial custody and if he wants and if the police wants his custody, so this 15 days period can be utilized in the first 40 days. I will give you this example. So if Paras G, I'm sorry Paras G for time and again arresting you. So suppose if Paras G got arrested today, that is on, what is the date, 12th January. So if he got arrested on 12th of January and if he is sent on a police custody of 2 days, so when will he be released? He will be released on 14th January. Now, in suppose on 14th January, if he's sent to judicial custody. Now, and if after 7 days, the police wants his custody back, right? If the police again wants to investigate him, and if the police asks for police custody, so again in these 15 days, so how many days are left of police custody? 13 days are left. So these 13 days on off can be taken in the first 40 days in cases where 60 days judicial custody is given, and in 60 days where 90 days judicial custody is given. I hope you people have, again, I would repeat it. So basically maximum 15 days police custody can be given. Now, it can be spread in parts. Either it can be given directly for 15 days or it can be given like PC, JC, PC. PC is police custody and JC is judicial custody. So if a person is sent to 2 days police custody, then he's again sent to 14 days judicial custody. Then he can again be remanded back to 7 days police custody or whatever amount. And then again, this can be done for first 40 days. So in the first 40 days, he can be given 15 days police custody in parts or directly at a stretch if the offense is of punishment which is less than 10 years. And for offenses having punishment greater than 10 years, it is 60 days. Okay. I was being told that 2-3 of my students have also joined. So I would again explain it in a different language now. So एक बार मैं आपको इसको हिंदी में भी explain कर देती हूँ because 2-3 of my students are more comfortable in हिंदी. देखिए, maximum custody पुलिस custody होती है 15 days की, ठीक है? So 15 days is पुलिस custody. अब अगर मान लीजिए 10 साल से कम का ऑफेंस है जिसमें जुडिशियल कस्टडी आपकी 60 डेज की होती है, 10 साल से ज्यादा के ऑफेंस में 90 डेज की जुडिशियल कस्टडी होती है, ठीक है? अब 60 डेज का अगर आपकी जुडिशियल कस्टडी फॉल करती है तो आप पहले 40 दिन में, 60 डेज के केस में पहले 40 दिन में इस 15 दिन की पुलिस कस्टडी को या तो एक साथ भी दे सकते हैं या पार्ट में करके दे सकते हैं। और अगर आपकी मैक्सिमम जुडिशियल कस्टडी 90 दिन की है तो आप पहले 60 डेज के अंदर 15 डेज को एट अ स्ट्रेच भी दे सकते हैं या पहले 60 डेज में 15 डेज को इन पार्ट दे सकते हैं। बट इन नो केस police custody will extend beyond 15 days, but you cannot extend the period of police custody. Okay, so this was a landmark change which was there in the BNSS. Okay, next, the 8th major change was it has been made contemporary. That is, in all the provisions, audio, video, electronic means words have been added. Okay, so audio, video, electronic means have been added in mostly all the provisions. The ninth major change was detention of under trials. Okay, section 479. What do you mean by under trials? Who are under trials? Under trials are the ones, for example, if Mr. X has committed a crime, or if Mr. X has alleged to have committed a crime and he has been arrested. So till the time the trial is not over and if he's arrested, he will be considered as an under trial. So under trial persons are the ones who have not been convicted but are under trial and are under imprisonment. Okay, so these are called under trial. So initially in the CRPC, what was the maximum period of detention? So as per the CRPC, if an accused would have spent half of the maximum period of imprisonment in detention, he must be released on personal bond. But this does not apply to offenses punishable by death. So for example, in the case of Paras, as I just mentioned, so suppose if he has committed a crime which has a maximum punishment of 10 years, and if he has already been there in the prison for 5 years, so now since he has already, and the trial is not over, he's still under trial, so if he has spent half of that period in imprisonment, then he must be released on personal bond. But there was an exception to it. The exception was that this clause or this section will not be applicable to the accused persons who are alleged to have committed offenses punishable by death. But again, in 479, this provision was enlarged and two more exceptions were added. So basically, this provision of half imprisonment will only will be applicable to all except the ones who have committed offenses punishable by death or offenses punishable by life imprisonment, and against habitual offenders, that is against whom proceedings are pending in more than one cases. So two more categories of people were added in the exception list under 479. I repeat, under trials are the ones against whom the trial has not been completed and they are under imprisonment. So for all these under trials, there was exception. So basically, they had to be released if they have already undergone a period of half of the imprisonment in detention. Now, again, there was exception for the people who have alleged to have committed offenses punishable by death. They were given an exception in this section, and now this section is enlarged to two more categories, that is offenses punishable by life imprisonment and persons against whom proceedings are pending in more than one case. Okay, last change for today is timelines. Timelines for procedures have been added in the new act. Okay, so the BNSS prescribes timelines for various procedures. For example, it requires medical practitioners who examine rape victims to submit their reports to investigating officers within 7 days, as per section 184. Now, section 309 clause 2 says that judgment within 30 days of completion of arguments should be given, which is extendable up to 45 days. So if arguments have been completed, then judgment has to be given in 30 days. Informing the victim of progress of investigation within 90 days under section 193, and framing of charges by a sessions court within 60 days from the first hearing on such charges under section 251 BNSS. So again, few sections have become time bound as per the new BNSS. I will just have a quick recap of all the sections so that all of you can also just have a quick revision. The first change, let me just have a quick recap. The first change is the registration of zero FIR. Initially, zero FIR was not a statutory provision, but in the new act, zero FIR is a statutory provision. That is, if a victim has gone to a police station which does not have a jurisdiction to register FIR, they can file an FIR without number. Since this FIR is without number, that is why it is called zero FIR. Okay, so this police station can file a zero FIR and then transfer it to the police station whosoever has jurisdiction. Second was hierarchy of courts. Under this provision, Court of Metropolitan Magistrates have been abolished, and now there is only court. There are only courts of judicial magistrate first class. Third, handcuffs. Now, as per 43 clause 3, there is a discretionary provision which gives a discretionary power to police that in cases of habitual offenders, organized crimes like terrorist acts, drug-related crime, illegal possession of arms, ammunition, murder, rape, acid attack, etc., in all these cases, police officers can use handcuffs. Again, forensic investigations, it is very important, since all evidences which are collected in the investigation helps the court during trial. So according to 176 clause 3, all offenses which are punishable with at least 7 years of imprisonment, forensic investigation has been mandatory. Again, as per 105, when a police goes for search or seizure of property, they must use audio, video, electronic means during this investigation, and preferably mobile phones. So whenever they are investigating, they can use mobile phones. So now in India, police have also started using body cameras. Now, again, the court, apart from asking for specimen signatures on handwriting, can also ask for voice samples, which were, like, as I just mentioned, were asked in Shinabura murder case. Police custody. Now, in custody, it is written that police custody, which is of maximum 15 days, can be either taken at a full stretch for 15 days or can be authorized in parts in 40 days, where judicial custody is of 60 days, and in parts in the first 60 days when judicial custody is for 90 days. Again, the development was that in all the provisions, audio, video, electronic means were added in all the provisions. With respect to under trials, the maximum period for which the under trials can be detained is half of the period for which they have alleged to have committed the offense. Now, again, this provision had an exception of people who are punished or who are alleged to have committed offenses punishable by death. But now this provision is enlarged, and it will also extend to people who have committed offenses punishable by life imprisonment, or persons against whom proceedings are pending in more than one offense. And the last and most major change was that all these procedures, as you can see on the screen, have become time bound. So basically, timelines have been provided for all these sections so that there can be speedy justice as per the new Bharatiya Nagarik Suraksha Sanhita. So that was all for today, and thank you for being a wonderful audience. In case if you have any doubt, please feel free to ask.
Thank you so much, ma'am, for taking such a wonderful session of BNSS. There are some queries during the session. I will read for them for you.
Sure.
Zero FIR means anywhere we can file a FIR.
Yes. So zero FIR means in case if there is a victim and he does not have recourse to a police station where it has jurisdiction, he or she can go to any police station, get an FIR registered, but this FIR will not be numbered. Acha, you must have seen FIRs are with number. For example, it is 238/24, hypothetically. So these FIRs will just not have number. That is why they are called zero FIRs. And then these zero FIRs can be transferred to police stations having jurisdiction.
Ma'am, next question is from Arth Shah. Ma'am, what is procedure for transfer of FIR from one police station to another?
Okay, so basically, once the zero FIR has been registered, okay, so what this police station will do, this police station will understand the nature of the crime. So they will understand where does the where does the jurisdiction for that offense lies. So once they find out the jurisdiction, then this police station transfers the FIR to the police station which has jurisdiction.
The next question is about, can you please explain our recent change, 7th change, that is police and judicial custody?
Okay. See, police custody, again, police custody maximum police period for police custody is 15 days. Okay. And maximum period for judicial custody is 60 or 90 days depending on the crime. So for offenses which are punishable up to 10 years of imprisonment, okay, for smaller offenses, maximum judicial custody that can be given is 60 days. That is before filing of charge sheet, okay. And for offenses greater than 10 years, maximum judicial custody before filing of charge sheet is 90 days, okay. Now, initially, the rule was that this 15 days police custody. So suppose if, I'm sorry that I'm giving your example time and again. So suppose if I send you to police custody, if I send you to PC, and once this police custody of 3 days end, now if you are sent to judicial custody, okay, so now this person could not be sent to police custody again. But now, as per the new BNSS, it says that this police custody can be given either as a whole for first 15 days, or it can be given in parts. So in parts means, for example, starting from 12th January, or say starting from 1st January, for the first 40 days, it can be given in parts for 15 days in the first 40 days. Do you get my point? So that is 40 upon 60 and 60 upon 90, that you have to remember. So if your case lies of 60 days JC, then 15 days PC can be given in the first initial 40 days, either at a stretch or in parts. And if your case lies in the second part of 90 days JC, then your police custody can be given at a stretch for 15 days in the first 60 days, or in parts in the first 60 days.
The next question is from Archa. How will magistrate be able to handle cases in a time-bound manner under new laws?
How will a magistrate be able to handle cases? So, see, basically the thing is, the timelines that are being given for magistrates, they are very specific. For example, the magistrates are not made so there is not a restriction on the magistrate to complete a trial within a certain amount of time. The timelines are given for different provisions. For example, if arguments are over, suppose if arguments are over, the judge has to give judgment, right? So this judgment, if you take another 1 year just to deliver judgment, it will not serve justice to the people, right? So now what they have done is they have given timeline for specific provisions. So not all cases have become time bound. So criminal cases are not become time bound. It's just that few provisions here have been given timelines. So for example, if arguments are over, then the judge must deliver judgment in the first in 30 days after the completion of arguments, and which is extendable up to 45 days. So only few provisions are time bound.
The next question is from Ms. Simran Mutha. What do you mean by voice sampling? Please say that again.
Okay, this I will explain. Suppose, as I just mentioned, that in investigation there is forensic investigation also, and suppose if Mr. X is arrested and if his phone has been, okay, and in this phone there are few audio clips, right? These audio clips, I accuse you that this is your voice. You say that this is not my voice. So now what remedy does the court have? The court will ask you to give a voice sample, that you give your voice sample. Now the forensic team will match it with the voice that they have, okay? So if the sample matches, then it will be considered as a valid evidence.
The next is just a second. Ma'am, what is the procedure for recording confession by a magistrate?
Okay. The process for recording confessions by a magistrate is, initially it was CRPC, there was section 164. In section 164, it was being written that once, okay, you must have seen that confessions before police cannot be recorded. So now suppose if a person wants to record his confession, how will he do? He will go before a magistrate, okay, and if he goes to the police, then the police will again take him to the magistrate. Now the magistrate will explain it to him that he's not bound to give this confession, okay. So now after explaining and after understanding that this person is recording this confession without any fear, without any threat, and which is again as per his own will, once this magistrate is satisfied, he can record his confession, and then he can put it on record.
The next question is, ma'am, what is the difference between metropolitan codes and the other one which you mentioned?
Yes. So as per CRPC, initially, though, for example, Bombay, Ahmedabad, so these metropolitan areas were already defined, but apart from that, population exceeding 10 lakhs were considered as metropolitan area. Okay. And others were, the states could have designated areas having population more than 10 lakhs or 1 million as metropolitan areas. So, hmm, okay. Sorry. So, what was I saying? My it got distracted. Yes. So basically, metropolitan areas were the one which were having population more than 10 lakh or 1 million. Now, the judges which were there in the metropolitan areas were called metropolitan magistrate, and in non-metropolitan areas they were called judicial magistrate first class. I will give you an example. Ahmedabad is a metropolitan city. Okay. So in Ahmedabad, any judicial magistrate first class who's sitting here will be called as a metropolitan magistrate, whereas if it is some other city which is not a which is a non-metropolitan city, for example Surendranagar, there a metropolitan magistrate will be then referred to as judicial magistrate first class. But the new act basically has abolished the courts of metropolitan magistrates, and there will only be judicial magistrate first class. There will no longer be a post of metropolitan magistrate from 1st July 2024.
The next question is from Mr. Aftab. In which section 0 FIR provisions is covered in BNSS Act?
Yes. So basically in BNSS, as we know that FIR is in 173, in the same provision, there is a provision of 0 FIR also.
The next question is, can judicial custody extended after 40, 60 days or 60, 90 days?
Judicial custody cannot, okay. We have to understand that judicial custody here, what we are talking about is before filing of charge sheet. Okay. So before filing of charge sheet, it is 60 days and 90 days. Okay. That is one. Again, once this period gets over and if the charge sheet has not been filed, then the accused gets a benefit of default bail. Okay. So again, in rare cases where the judge feels that yes, he should not be given default bail, in a very rare case, in rarest of rare cases, generally this default bail is denied and a reasoned order is being given by the judge.
And the next question is from again Aksha. That is, ma'am, what about bails in special laws? It will be in new or or a special law.
Okay, always remember one thing, that if there is a discrepancy between special law and general law, always remember that special law prevails over general law. Okay, so be it CRPC, be it BNSS, always remember when there is a conflict, if there is a conflict between a special law and a general law, always remember that special laws will prevail. Parasji, I'm really sorry, but actually I am running out of time. What we can do is, in case if it is okay with all of you, uh, you people can note down my email ID and the institute's number also. In case if you are comfortable, then you can is it possible that you just give me your questions and I'll answer all of them, because I have to reach at some other place.
Sure, ma'am.
Is that okay?
Just give us 5 minutes more. I will provide the email ID to them so they can reach out to you.
Yeah.
Just give me 5 minutes more.
Just one second. Yes, please.
We will share Ms. Rina in the Legal Vidya free webinar group. Just please stay for 5 minutes more and we will wind up this session.
I'm really sorry. I really wanted to address all the questions, but because of paucity of time, I could not. And trust me, Palji, I'm really sorry. Actually, I forgot that I have a session today.
No
Sorry.
worries.
Yes.
So, as we come to the conclusion of this insightful and engaging webinar on the BNSS impacts and implications for our modern criminal law, it is my pleasure to extend a heartfelt vote of thanks to all of you for being a part of this session today. First and foremost, I would like to express our deepest gratitude to our esteemed speaker, Ms. Anshu Sharma ma'am, for sharing her wealth of knowledge and expertise on this exciting and critical topic. Your practical insights, valuable experiences, and clear guidance have given us a deeper understanding of how behavioral and how law is shaping in our modern criminal law. We are truly inspiring by your words and grateful for the time and effort you have invested in empowering us with this knowledge. A special thanks to all our participants for your active engagement and thoughtful questions throughout this session. We hope this webinar has not only enhanced your understanding of how BNSS influences criminal justice, but also motivated you to explore its transformative potential in shaping legal systems. Also, I apologize from all of you, those who have not answered the queries. You can mail your queries to this email ID. They will answer on their email ID. Once again, thank you all for your presence, and we look forward to seeing you at our future events. Have a wonderful evening and happy learning.
Thank you so much, Legal Vidya, and thank you, Parnasji. Take care. Have a nice day.
Have a nice day. Here are the contact details which is shared by Mr. SB Vakil. Also, I have already provided the feedback form and it will close after 6:10. So, thank you so much who have joined. Have a nice day. Thank you.